Good evening. My name is Faisal Elkhatib, and I'm with the Better Informed Housing Corporation. I've got Stephanie Arcenty with me. She's an attorney, and we're going to talk about foreclosures today. On the borrower side, foreclosure defense work. Stephanie, thank you for joining us today.
Thanks for having me.
So really quick, just want to let everybody know, we are the Better Informed Housing Corporation. You can reach us at betterinformed.org at 218 North Jefferson, Suite 103, Chicago, Illinois. You can call at 312-533-2688, or you can email us at neighbors@betterinformed.org. This is a live show. Unfortunately, there are some technical difficulties regarding the live streaming. The internet is down. You can call your Comcast representative and tell them why are they shutting down the public broadcasting systems over here at CAN TV. But putting that aside, we are live on TV and we are at Facebook Live, so long as I have battery, and then we'll lose the Facebook Live. But you can call us here at 312-738-1060. We're taking calls. So, Stephanie, tell us a little bit about foreclosure defense and what's going on in the world today of foreclosure defense. Are there defenses out there? What can borrowers do to protect themselves?
Sure. Well, there are a few ways you can protect yourself as a borrower in foreclosure. What used to be, there was something called a grace period notice that was required to be sent by a lender. And that statute was an Illinois statute that sunset, unfortunately, on mid-2016. So that particular notice isn't necessarily required to be sent anymore.
So if I recall, back in when the crisis hit in 07, 08, 09, I remember there were a ton of defense that we had available to defend borrowers, including the grace period notice, including various other things within HAMP. You had some HARP issues. You had, what we called the chain of title in the ABC game, which is where the banks had sold the mortgages multiple times and lost who figured it out. Now, as foreclosure defense attorneys won in many of these cases, the banking lobby changed.
That's correct.
A lot of the laws and made things difficult. So every time we would get a win, they would change the law so that win became almost meaningless anymore. So we can talk about that banking lobby and what they've done to really hurt the homeowner, but I kind of want to focus on, if you don't mind, what defenses are available now left today. Grace period notice, that was a requirement that they had to send notice. That's gone.
Right. Except, although under the CFPB, the Consumer Financial Protection Bureau rules, there is a section under the Real Estate Settlement Procedures Act that requires a certain grace period prior to acceleration and filing of a foreclosure complaint after somebody defaults on their loan. So that's 120 days. They're supposed to wait, lenders are supposed to wait 120 days after you default on your loan.
So that's a requirement pursuant to the RESPA, and every residential home signed a RESPA.
Right. So that governs residential mortgages. Right. That's correct.
For homeowners, right?
That's
residential.
correct.
And that could be homeowners or investors as long as it's a residential home loan.
That's correct. Right.
1 to 4.
So yes, 1 to 4 units.
Gotcha. So it could be a 3-unit building using that same residential loan dynamic or paperwork, it would have that condition. So that's pretty cool. So are they required to do anything within the 120 days?
They are supposed to be sending out a written notice. It doesn't have to be mailed, but it does have to be in writing, indicating that you are in default. Here's the amount of money you're owed, and also that you owe, and then also, giving you options.
Available loss mitigation options to fix the situation.
Exactly. Now, here's your local hotline that you can call.
So other than sending this piece of paper, do you have to do anything more within that period? Or is it just send the paper and wait?
It's basically send the paper and wait, so there was a more stringent, as I think you're referring to, the Illinois law, that's the grace period notice, which is gone right now, right, which actually the Association of Foreclosure Defense Attorneys, which I'm a part of, is trying to put back on the books for the protection of borrowers.
So now,
because a lot of times, go ahead.
Well, now that, all right, so we've got the notice period. If they don't send this letter out and they don't provide, and they don't wait the 120 days, does that unravel the foreclosure if they file it too soon?
Unfortunately, because it's not written into Illinois law, which is actually what we're trying to get done,
Okay.
you can bring it as a counterclaim if there's a violation of RESPA, the Real Estate Settlement
I
Procedures
see.
Act.
So it'd be a violation of RESPA that you bring as a counterclaim.
That's correct.
But can you bring it as an affirmative defense, for example, as a condition precedent requiring to file the foreclosure, or no?
Well, you could try to file a what's called a 2-619 motion, which is
Okay.
a motion to dismiss a complaint based on a failure of a condition precedent,
Right.
which that would technically be. But I haven't seen that argued too much because, again, it's not in Illinois law right now. So what it is a federal statute that you can have the right to bring a counterclaim under or a
For violating
claim
that RESPA piece.
That's correct.
But it's not in the mortgage documents themselves. So it's not like an agreement that they had to abide by. It's simply the fact that federal regulation says they had to wait 120 days.
That's correct. But a lot of times what will be in the mortgage document itself, which I'm seeing sometimes it's not there anymore, is what's called a notice of default or
Okay.
a notice of intent to accelerate.
Gotcha.
And so that is definitely something that, under Illinois law, it depends on the federal, or sorry, not the federal, the appellate court and the case. But I think it should be a condition precedent. But there's a line of cases that says, okay, well, if you don't have the proper type of notice, that's a condition precedent. But if you don't mail it, that's not necessarily a condition precedent. So it's a little tricky as to when you can bring it and in what form. Can you bring it in a motion to dismiss, or do you have to name
So
it
the
as an
judges are
affirmative
really,
defense?
the judges, really per judge and per county, there's different interpretations of that piece.
That's correct.
But for sure, there's at least a counterclaim on the rest of the piece for failing to provide proper notice if they didn't do it the right way.
That's right.
So what else do we got? Other than this notice piece, the notice to accelerate, what other defenses do homeowners have in foreclosure?
Well, if they haven't been served properly, they can always come in and say, listen, file what's called a motion to quash.
So they won't just show up in court and say, hey, what's up, I didn't even served.
Right.
There's certain proper procedures they need to, so I guess we still have this technical civil procedure arguments that exist, such as proper service. So in every lawsuit, that there needs to be you file the complaint, or in this case a foreclosure complaint, the plaintiff files that, and then they actually have to send someone out to physically hand the documents to the person being sued. That's in every single lawsuit.
Or attempt to do that.
Or
That's
attempt
correct.
to do that.
Right.
Now, interestingly enough, diligence is a requirement, and if I just show up to court in any other courtroom, right, if I'm not mistaken, that's not a waiver of service. However, that's different here.
Right. So in a foreclosure case, unfortunately,
Another thing the banks did to change the laws to really mess with borrowers, but okay, go on.
Yes, so this was sort of added into the Illinois mortgage foreclosure law a little bit late. There is a time limit during which you are allowed to, as a borrower in foreclosure, bring a motion to quash if you appear in court. So it is
So
60
motion to
days.
quash, really quick. So motion to quash essentially says the person being sued was not properly served. Someone did not properly show up to my door and hand me the paperwork in my hand, or give it to someone in my house that is over the age of 13.
That's correct.
That lives in the house that I live in.
That's correct.
Right? So
Or a family member.
Or a
actually,
family member.
Now it's actually recent case law says if it's a family member and they're related, even if they don't live there, they're still considered a family member and can accept service on your behalf in what's called
Really?
substitute service. Yeah,
So
that's very recent actually.
even if it's not a person who lives in that house.
It used to be the family member was defined as a person who lives at your house.
Gotcha.
Now it's a person who lives at your house and actual relation are encompassed
So
under
if
the
my
family member.
fourth cousin, who I've seen never, just happened to be at my house the day this guy serves it, that counts as service.
I'm sure there's a cutoff. You could probably make a good argument that your fourth cousin isn't considered quote unquote a family member, but yeah, that's what I would say.
But the point being is now you have to be conscious of the fact of who got served in the household.
That's right.
So the motion to quash quashes that, and in every courtroom, in every type of lawsuit that exists in Illinois, if you never got sued, you can technically show up on the last day of trial or the first day of trial and say, I never got served, and quash the whole case. You can even actually show up after judgment, after everything. If you haven't appeared or done anything in the case, you can show up post-judgment and say, hey, you have to undo this, and a motion to quash could unravel the entire lawsuit back to the beginning. In every other case, right? Except foreclosures.
Well, so yeah, in a foreclosure, we have this limitation of 60 days from the earlier of when you participated in a hearing or when you filed an actual appearance in a matter.
So even in other cases, if I file an appearance, it doesn't waive my motion to quash.
No, it doesn't. In foreclosure, it does.
In foreclosure, if you file an appearance, so they changed the laws exclusively specific for mortgages only. That's what the banks did when they went down to Springfield and they lobbied our representatives to change the laws to make it easier for them to take our houses away from us. Just to make sure I'm clear, that if you show up to court and say, hey judge, I'm here, that in itself is a waiver of jurisdiction if you don't file a motion to quash within 60 days. Is that correct?
If you don't file a motion to quash within 60 days, if you show up, yes, that's correct.
You've waived the ability to challenge jurisdiction, the personal jurisdiction, which doesn't exist in any other type of case anywhere in the books.
Right.
But so technically, if you've been served with this stuff, or you haven't been served, you know there's a case going, the last thing you want to do is just show up to court and tell the judge, hey, what do I do? Because that could start the clock ticking and create a problem for you.
Yeah, unfortunately, it punishes you for showing up, and it doesn't make a lot of sense. But that's another thing that we really want to work on is in the Association of Foreclosure Defense Attorneys is to lobby
and
for.
We lost my Facebook Live.
Is to lobby for sort of.
Going back to the rules to make the match everything
Pretty much make it an even playing field. That's correct. Getting rid of that.
So we've got personal jurisdiction, so long as you haven't showed up and you haven't done something to waive that. And if you ever want to know exactly what that is, make sure you talk to a foreclosure defense attorney who can help you with that. So I'm going to quickly just remind everyone we are Better Informed Housing Corporation. We're located at 218 North Jefferson, 312-533-2688. You can call us after the show if you have any questions. Neighbors at betterinformed.org. We are a live show, so you can call at the bottom of your screen. You'll see the number is 312-738-1060. So Courtney, so we've got two, we've got the technical arguments of whether they haven't filed the complaint right or they've made mistakes in how they did the complaint. But now they use a form complaint mostly, so it's kind of by statute.
That's right.
So what other defenses are there that people have in foreclosure?
So we already discussed the notice of default and the intent to accelerate.
Correct.
There's not a lot left. There are some other counterclaims that you can bring under the Real Estate Settlement Procedures Act. And those are essentially if you have applied for a loan modification, for example,
Okay.
and there's something that's called a dual tracking provision, right? So
In RESPA.
In RESPA, right? So when you've applied for a loan modification, you're on this track where the lender, the servicer, then has to respond within a certain period of time to say, yes, we've received your loan modification application, thank you. Yes, you are missing documents. No, you are not missing documents. We are currently
So short
reviewing
sales
it.
included in that process, or is it only loan mods?
Short sales are a different animal, but
Okay.
this is all loss considered
it's under
loss mitigation, right?
Okay.
Yeah. So and so then that sort of track is going while there's the litigation track going on.
So they're the dual tracking, which was they're notorious for in the old days.
Right.
Yes, we're talking to you. Yes, we're handling your loan mod. Yes. But while they're talking to you on one side, they're dual tracking on the other side, and they're actually going forward on the litigation. So by the time you finally get an answer on your loan mod got denied, they've already taken your house.
Right, exactly.
And so there's RESPA provisions in the Real Estate Settlement Procedures Act that actually protects, from a federal standpoint, that gives you federal counterclaims that the borrower can use against the bank. Is that correct?
That's correct.
So now, there used to be the ABC of title, right? So if I remember, Mears, I have an assignment from one bank, Deutsche Bank, trust number, blah, 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 went to another trust, which went to another trust, and then passed down the securitized pool, and it just became this long chain of people who had my mortgage or had my note.
You're talking about standing
Arguments.
Right,
Absolutely.
Yeah. That's, I don't think the judges are taking that type of argument as seriously anymore, unfortunately.
Part of that is because of the Bassman case.
The Bassman case,
So
that's
there was
correct.
a lawsuit essentially where the judge. So not only were the banks effective in changing actual laws to make it more difficult to defend ourselves and defend borrowers, the judges themselves passed and ruled in what we would say not in our favor, but they ruled in certain ways that actually cut off a lot of the defenses or some of the defenses that borrowers had, to force the banks to prove who they were and that they actually had a right to foreclose on your property. Is that correct?
Yes.
So that defense really isn't available. So it really looks like...
It is, but it's watered down a lot. And then and actually there's some cases, there's a recent line of cases where a note, a promissory note, right, which is in combination with the mortgage that you sign, which represents the amount that you owe and the contract surrounding the actual amount that you owe the bank.
So just to recap, you got a promissory note that says,
right,
I owe $300,000, but you have the mortgage that says, if you don't pay on the note, then we get to take your house and the mortgage.
Essentially, yeah.
So the mortgage attaches the note to the house.
Yes, it's a security instrument.
It secures the note to the house.
That's right.
Right, okay.
So, we have a caller.
We don't have a caller.
Oh.
Never mind. We lost the caller. Call back. 312-738-1060. We don't need to be so excited that you called. We always love to have callers.
Yeah.
So, going on, we were talking about that it's there, but it's watered down.
Oh, standing, right.
Standing.
So standing is as defendants and borrowers in foreclosure, representing borrowers in foreclosure, we would say, listen, you've got this, what you were referring to, this sort of chain here, and there was a securitized, there was a bundle of mortgages, and they were put into a trust, and that, there's an agreement that's called a pooling and servicing agreement,
right,
in reference to that trust, and
okay,
then that would get assigned to a different servicer or lender or whoever. And so we would say, listen, you can't prove that you currently are the holder of this note and have any interest in this property, right? That's been watered down because of Bassman, like you said, but then also because there's a line of cases that says even if the note that we just talked about, right, is assigned to the current plaintiff after, this is crazy, but it's true, after they file suit, that's still okay. And that was, I think, a Lopez case. The second district ruled in favor of the borrower to start and then reversed its ruling some months later and sort of just turned on itself entirely.
The appellate court flipped its decision?
That's correct.
So they issued another ruling?
I think they I don't know what the term is to take back your ruling, or
so they rescinded their ruling.
Rescinded, yeah, exactly.
And then they issued a whole new ruling that went in the other direction.
That's correct. Yeah.
That's not shady at all. Not even a little bit.
And I know our friend, the defense attorney who was handling that matter, has filed a petition for leave to appeal to the Illinois Supreme Court. So we'll see where that goes. And only a small percentage of those get accepted, but we're rooting for him for sure.
Absolutely. Well, we wish him the best of luck. So what other defenses are out there? So we've got a couple so far. Anything? So it seems like counterclaims are the way to go.
Yes, right now, been personally starting to bring a lot of these counterclaims based on the fact that, listen, my client has had a loan modification pending. They haven't heard back for months, and at the same time, we going back to this dual tracking issue, the plaintiff attorney, the attorney for the bank, would go into court and get summary judgment. Well, they're not allowed to do that under the Real Estate Settlement Procedures Act and the Consumer Financial Protection Bureau rules currently. They're not allowed to set the
So are those rules, the CFPB, are those actual mandated statutes, or are they more recommendations? I mean, does the CFPB have the teeth that it needs in order to...
I'm afraid for the CFPB currently in the current environment federally, but currently it is law.
So if the CFPB issues out a ruling or issues out a statement or issues out guidelines, those guidelines must be abided by lenders?
Well, there are guidelines, but then also they work to, put this into law. So it's actually in the Real Estate Settlement Procedures Act.
Gotcha.
So, right.
So it appears that there are still some defenses left available, but it appears that the best way to bring those is through counterclaims.
That's correct.
And the result that we've seen, and I'm sure that Stephanie has seen, is that when those counterclaims come forth and you file those counterclaims, it brings a pretty much an all-about stop to the process itself, the litigation, and now the defendant, the plaintiff, who was now the aggressor, becomes the defendant and has to defend against your counterclaims, especially if they're good ones.
Right, and we see a lot of settlements happen that way, fortunately.
Gotcha.
Yeah, or if not, we should.
Well, Stephanie, thank you very much for joining us. My name is Mahmoud Faisal Elkhatib. We're with Better Informed Housing Corporation. We are nearing the end of the show, so you won't be able to call us, but you can reach us at 218 North Jefferson, Suite 103. You'll go to betterinformed.org as our website, and our phone number is 312-533-2688, or you can email us at neighbors@betterinformed.org. Again, my name is Faisal Elkhatib. I'm here with Stephanie Arcenty. Thank you so much for tuning in, and we'll talk to you later. See you next month.
Thank you.